Good afternoon, everybody. Thank you for attending the webinar today. My name is Claire Brown and I work within the private client department at Edward Hanson Lewis Solicitors. I regularly advise clients on all aspects of private client law, including advice specifically in respect of their wills. The purpose of today's webinar is to try and provide you with some information on what you should think about when making your will. In terms of the timescale, these webinars are very much dependent on whether you have any questions at the end, but in general they tend to run anywhere from between 15 and 45 minutes. So we'll see how we get on today. So by way of introduction, I've tried to structure the webinar so that it is easy for you to follow. And therefore today, firstly, we will consider point 1, why would you need a will in the first place? Point 2, which types of will are available for you? Point 3, what the procedure is for drawing up your will. Point 4, what would the effect of marriage and divorce be on your will? Point 5, what would happen if you do not have a will in place? And point 6, finally, can you make your own will? I'll then conclude, and if you do have any questions, I'll provide you with my email address so you can send those through as well. So first of all, why do you need a will at all? Put quite simply, our advice is that everybody should have a will, regardless of their position or financial status. Your will is a legal document which enables an individual to clearly state their wishes in respect of their financial assets, along with other more personal decisions. The people who you decide to leave your assets to are referred to within your will as your beneficiaries, as they will benefit ultimately from your estate. You will also need to appoint your executors. An executor is the legal term which basically means the people who you choose to carry out the wishes that you have laid down in your will. It is obviously essential, therefore, that you would give careful consideration when choosing who to appoint as your executors, and it is essential that first and foremost they are capable in carrying out your wishes, that they are over the age of 18, and ultimately they are people whom you trust to carry out your wishes. There are other more practical considerations as well, which you may want to consider when choosing who your executors are. For example, if your chosen executors live closely to you, it may be easier for them to carry out your wishes in accordance with your will, as opposed to if they lived in a foreign country. Also, in your will, you may wish to appoint a guardian for any children you may have. Your will enables you to do this. However, it is important to bear in mind that there are interconnections with what your rights would be under family law, which your legal advisor will be able to discuss with you. And put briefly, this is in terms of who would have the necessary parental responsibility in law to be the guardians for your children, and is something which you will need to consider if you want to appoint a guardian within your will. You may also wish to state in your will what your wishes are in respect of your funeral. Some people may have very specific wishes and want to make them clear within the will document itself. And your will enable you to do this. Other people tend to be more happy to relay their wishes to their family members, and indeed there is no legal obligation for you to put down your wishes in respect of your funeral within your will. Indeed, you do not always have to set out what your funeral wishes are within your will, and I always advise our clients that this section within your will is more of a personal decision as opposed to a legal decision. And it very much depends on your personal wishes as to whether you want that clause to be inserted in your will or not. Also, one of the perhaps more important parts of making your will is to ensure that any potential inheritance tax liabilities which may fall due on your estate are minimised. Just to build on this point, currently there is a nil rate band in place for inheritance tax, which the current threshold stands at £325,000. In certain circumstances, you are able to transfer the use of your spouse's nil rate band, meaning essentially that this figure can be doubled. So for example, you would be able to use 2 times £325,000, giving you a total of £650,000. So for example, if your estate was to exceed this threshold banding, then inheritance tax would unfortunately be due, and this would be charged at the current rate of 40%. Obviously, this is quite a large figure, and therefore it is exceptionally important that inheritance tax issues are discussed with your advisor, and any ways possible to minimise the inheritance tax due is done through your will, if indeed inheritance tax is going to be a potential problem in the future. In addition, there are various exemptions and reliefs available in the tax legislation which can be made use of if they are planned for when you draw up your will. And indeed, you need to ensure that your will is drafted in the correct way to ensure that you can make full use of these exemptions and reliefs in the future to minimise any inheritance tax which may fall due on your estate. So moving on to the second point now, and the slide which we have in front of us is headed up which types of will are available to you. And so there are different types available, and the type which we would advise you to draw up very much depends on your family circumstances and which one would be most suitable for you. So first of all is your basic single will, and that tends to be the best option for an individual who simply wishes to state what their wishes are in terms of their estate, guardians, executors and beneficiaries. The second type of will available is referred to as a joint mirror will, and this tends to be a good option for a couple who have very similar wishes in respect of their will and which may reflect each other, hence the name of the joint mirror will. There are other types of will available, for example, a business will. This is a very useful type of will for anybody who has a business asset, whether they be an individual or a couple. And these can be very comprehensive documents to lay down what your wishes would be specifically for the business and how and if it's going to continue to run once you have passed away. Another type of will which is available is known as a lifetime interest will. This type of will is more complicated in its nature and tends to incorporate a trust which grants somebody a lifetime interest in any property which you would own. These types of wills, because of their more complicated nature, require a little bit more consideration and is something which your advisor will be able to discuss with you at the initial consultation in order to ensure that they are drafted correctly and in line with your wishes. So those are the main types of will which are available. However, there are other specialist types which we can draw up. And again, this is something which can be discussed with your legal advisor and are very much dependent on the circumstances of an individual and what their instructions are. When you draw up your will, if you do it through a legal advisor, there will always be an initial consultation with your advisor, and they will be able to make a judgment on which will is most suitable for you and advise you of why this is the case. So this brings us quite nicely onto the next slide, which lays out what the actual procedure is for drawing up a will. And this is very much specific to if you draw up a will with a legally trained advisor. So first of all, as I have just mentioned, there will be an initial consultation appointment whereby we will be able to discuss with you what your wishes are for your will and ultimately obtain your instructions on what you want to go into that legal document. After that initial consultation, your advisor will then be able to prepare a first draft of the wills for you. That first draft will be sent out for you to check through, and indeed at that stage it's important that if anything is not correct, there will be that time during the procedure of drawing up the will where any amendments to the document can be fulfilled in order to ensure that the final document is as accurate as possible. Once any amendments have been made and you are happy, along with your advisor, that your wishes have been laid out correctly within your will, a final draft will then be completed. An appointment will then be arranged between you and your legal advisor, and you will read through the final draft and ensure once again that this is in line with your wishes, and you will have the chance to ask any questions which you may have with your legal advisor to ensure that you understand how your will is being drafted and that your intentions have been met. At this appointment, you will also carry out the legal execution which is necessary to ensure that your will becomes legally binding. Until your will has been executed in the correct way, they are not legally binding. Legal execution involves you signing your signature on the document, and your signature must also be witnessed by two independent witnesses who must also sign in their capacity as witness, and the document must also be dated. It may seem obvious to add in at this point that time is very much of the essence from obtaining your instructions for the will right through to legal execution. But because of the nature of your will, it is always extremely important that they are drawn up as quickly as possible to ensure that they become legally valid as soon as possible, in the event that anything should happen in the interim period between you giving your instructions and the ultimate legal execution. So moving on to the next point within the webinar here, this looks at the changes in circumstances and what you need to consider in terms of your own circumstances. One common question which we get asked quite a lot is what the effect of marriage and also divorce would be on the will document itself. So first of all, if we look at what the effect of marriage would be on your will. When you marry somebody, this effectively invalidates your will, and so it is essential that you make a new will to ensure that any previous wills are not invalidated by the marriage, If you do not make a new will, then your estate may not pass to the people who you want to benefit from it. So it's always something which you need to bear in mind and certainly act upon if you're going to intend to marry in the near future. It is also worth mentioning at this point that it is possible to complete a specialist type of will if you are contemplating marrying somebody, or indeed if you are engaged. And this is known in the legal world as a will in contemplation of marriage. These types of wills are very useful if you want to ensure and certainly make your will now, but know that you are going to marry your partner in the future. You do have plans to marry, but you want to avoid having to make a new will once you are married. The second type of change in circumstance which is important in relation to your will is your divorce. So to elaborate on this point, we are specifically looking at a divorce by a court order, and certainly this would invalidate any provisions which you have made for your spouse. So just to build upon that point there, if divorce proceedings are finalised by a court order, then your will does not become void. However, any sections in your will in which you have referred to your spouse will be treated as if your spouse had passed away on the date of the decree absolute. This is the legal decree which you get once you are legally divorced. This may ultimately result in their share and provision in your will falling into the rest of your residuary estate. This indeed may not be in line with your wishes and may have quite severe implications for inheritance tax, as it will increase the value of your residuary estate, and you may not be able to make use of any spousal exemptions or reliefs. Therefore, it is crucially important that if you are going through divorce proceedings, you have your will reviewed and updated by a legally trained professional who will be able to advise you accordingly. So if we move on now to the next point within this webinar, which is what would happen if you do not have a will? And quite simply, if you do not have a will, then your estate will pass by law under the rules of intestacy. These rules of intestacy have been recently amended, with the new rules coming into force on the 1st of October 2014, last year. It is important to highlight at this stage that these rules are rarely what you think they are. I regularly speak to clients who think that they do not have a will in place at the moment, but, for example, this would simply mean that everything will just go to their partner and children anyway, so why do they need a will? Unfortunately, 9 times out of 10, their thinking is incorrect, and the rules of intestacy, which will take precedence, are not always what they thought they would be. The rules of intestacy are fairly complex and very much depend on what your family circumstances are and how your family tree is set up in terms of bloodline as to who is going to inherit what. Essentially, I suppose the important point to take away from today's webinar is that in order to avoid a set of legal rules such as the rules of intestacy dictating where your assets should go, you can avoid this altogether by making sure that you have a legally executed will drawn up which sets out what your wishes are. So this takes us quite nicely onto the next point within the webinar, which is headed up on the slide you have in front of you and is a common question which I hear on a weekly basis, and that is, can I make my own will? A lot of people think that they can make their own will, or indeed purchase a ready-made will, for example from W.H. Smith. I'm sure a lot of you will have also seen various adverts such as Groupon, Voucher, etc., which offer inexpensive will services. Although to an extent it is true to say that yes, you can make your own will, homemade wills involve risk. They may result in your wishes not taking effect, and at worst, your will may not be deemed as legally binding. It is always safer to have a legally trained professional draw your will up for you to ensure that it is correct. Your legal advisor has had many years of training and can advise you of all the legal implications in drawing up your will, and also of any inheritance tax implications which may fall due on your estate. Your legal advisor will also be able to offer you options on how you can minimise these risks and any inheritance tax implications. Indeed, by way of example, I've seen many wills drawn up where the wishes of the testator or the testatrix, whose will it is, have not necessarily been conveyed into the will, as it's not been drafted correctly. And certainly simple things such as an error with punctuation in the drafting can have severe consequences on the ultimate carrying out of the will. So This brings us on to our conclusion for our webinar today. As I said at the beginning of the webinar, it's important, and I would always advise, that everybody should have a will. Some people think that because they are not exceptionally wealthy, or they do not have children, or their financial assets are simply not worth enough at that time, that they do not need to make a will at all. I would hope, therefore, that this webinar has been useful in proving this not to be the case. If you are sensible enough to have already drawn up your will, then it is also just as important to make sure that it is up to date. Obviously, people's circumstances do change throughout their lives, and it is always advisable to pull your will out at least every couple of years, just to check that it is doing what you want it to do. If you are unsure at any stage that your will is doing what you intend it to do, then your legal advisor can review it for you and discuss your wishes in order to make sure that your will is fully up to date. If the only updates which you require are simple ones, such as, for example, a change in an address, then this can normally just be logged with your will, and you do not need to update the substantial document itself. However, you may decide to change your wishes more substantially. For example, if you wanted to change who your executors are within your will, or to change who your beneficiaries are, or indeed to appoint different guardians. In respect of these more substantial changes, you would need to update the will altogether. In addition, your financial position may also be likely to change over time, and therefore this also needs to be considered in the way in which your will is drawn up, specifically in respect of the tax implications on your estate, in order to ensure that these are minimised through the drawing up and drafting of your will. Whatever the scenario is, it is always important that you review your will regularly and keep it as up to date as you can. That brings us to the end of our webinar today. I hope that you found it useful, and as I mentioned at the outset of the webinar, if you do have any specific questions, then please feel free to email me on claire.b@ehlsolicitors.co.uk. Thank you for attending.